algorithm got me. Saw an article about Meghan Markle. That is not normally anything I'm going to click on, but it also had the word lawsuit in it. I fell for it and started to read it. Saw that it was a defamation lawsuit. Okay, well, this is, maybe relevant because we're dealing with that with the Manson cases. The Depp case is up on appeal. Big verdict there. What is this thing? Now, I know better than to trust what a news article says about the case. Instead, I logged on to the federal website called Pacer that allows you to look up the actual documents involved in the case and see what the real story is. And I was pretty surprised by what I saw. There are lawyers trying to kick the judge out, lawyers trying to kick themselves out, lawyers trying to kick the lawsuit out. It's pretty crazy. Let's take a look at it. So the lawsuit was filed in March of this year by Meghan Markle's half-sister, Samantha. And in it, she alleges that Meghan Markle defamed her in some email traffic, some statements made by some agents of hers, statements that were later published in a book called Finding Freedom, and in the interview with Oprah. So looking through the lawsuit, you see it's in federal court. Why is this a federal case? It's just defamation. So a case can wind up in federal court either if it's on a federal question involving a federal statute or if it involves citizens of different states. That's called diversity jurisdiction. And if the case is over $75,000, then a party can have their case put into federal court typically. So you'll see that erroneously sometimes reported in the media, and it was in this case that Samantha Markle is suing for $75,000. And that's not true. She just has to plead that she's suing for at least $75,000. That's the jurisdiction amount. So we don't know whether she wants $75,001, $750,000, $7.5 million. Who knows? She just pled the jurisdictional amount of $75,000 and that she and her half-sister, Meghan Markle, were residents of different states. So the case gets into federal court, involves the allegations I mentioned, and it has 2 counts in it. Remember, your complaint has to state at least one cause of action in it and the elements of that. And she sued for defamation and defamation by implication, which was what occurred in the Depp case. And that is, the statements are not necessarily defamatory if you just read them on their face. They don't say anything bad. But if you put the statements together, you juxtapose them, or if there's an omitted material fact or something like that, so that if you read this and you go, aha, A plus B, yeah, I get it, this person's a scumbag or whatever. It can be defamatory even if the individual statements separated alone out of context don't say are not defamatory by themselves. So the Duchess, through her attorneys, respond to this complaint. They file a motion to dismiss based on statute of limitations and also failing to state a claim upon which relief can be granted. In other words, you didn't meet your basic obligation to set forth in a legally sufficient way all the elements of the things that you're suing me over, defamation and defamation by implication. So some of it's too late, and the rest of it doesn't amount to defamation as a matter of law anyway. Was going to be their argument, but the case derailed before that was ever heard. Just 1 month into the case, Samantha Markle's attorneys file a motion to the court to withdraw out of the case. They want to get out of the case, and they cite fundamental, irreconcilable differences with their client on the strategy of the case and aspects of the case. I don't know what those are. Who knows what was going on there. They want to get out of the case, and they note that the plaintiff here does not even have another lawyer yet, and also probably wants to remain anonymous. Now, what you may not know is once you appear in front of a court on behalf of a client, you can't leave out of there until the court says, yeah, you're relieved from your obligation to continue in this case. It's not your decision. You have to stay in the case. So when you appear for somebody, it's a pretty serious situation. And in fact, the court here denied this motion and said, well, we can't keep her confidential and not be able to address documents to her if she doesn't want that to happen, and no other lawyer in the case. So until you decide how you want to handle that, you're staying in the case. The attorney comes back a couple of weeks later and files another motion and says that he's been contacted by another law firm that will represent Markle, and that Markle has informed him that he can tell the court that she's going to be represented by somebody else, but then says that this new law firm is not communicating with him about filing this motion to get the counsel substituted. And so please, dear God, court, just let me out of this case is basically the substance of this motion. That's not really the stance you want to have with your lawyer, is it? Eventually, this gets worked out, and the lawyer is able to kick himself out of the court. The new lawyers are in place. We're ready to get on with this thing, right? Let's see what this complaint's about. Let's see if this motion to dismiss has any merit to it. Let's get on with this case. Nope, it's not going to work out that way. Instead, the new lawyer abandons the original complaint and files an amended complaint that is significantly different than the first one. And probably before people really have a chance to digest that, this lawyer is further active in moving to disqualify the judge from the case. Of course, if you move to disqualify a judge, the judge shouldn't take that personally. It's their job to remain impartial, but still, do you really want to do that? Shouldn't you make sure you're right if you do? In this case, here was the basis for asking this judge to be disqualified. Judge Honeywell was nominated to her current position as a federal court judge by Barack Obama, the 44th President of the United States. And then it goes on to talk about how the Obamas have had a relationship with Prince Harry and suppose Meghan Markle as well. They don't say the judge has any relationship with these people or that the judge even has a relationship with Obama. Just that Obama has a relationship with the Markles and that the judge had been appointed by Obama 12 years ago. There's no indication there of any bias. They say, well, the public may perceive bias or whatever. Nah, that's weak. And this was denied. Was moving to disqualify this judge something that was a source of the disagreement between the original lawyer and their client, or was it an original idea of this new lawyer? I don't know the answer to that. That motion was not remotely persuasive to me, nor to the court. So on with the rest of the show, which is the amended complaint. The amended complaint is shorter, drops out a lot of the allegations of defamation, streamlines the entire lawsuit, and drops defamation by implication. Now there's just a count for pure defamation and injurious falsehood, which is basically defamation. So there's the 2 counts in there, but the implication count is gone. Now Markle's attorneys appear and move to dismiss this amended complaint on several bases that they outline in their arguments. The arguments boil down basically to 2 things, which is 1, the things that the plaintiff says were the statements that are defamatory are, as a matter of law, not defamatory. And that can be decided by the court on a motion to dismiss because the statements are set out in the complaint and the court can look at them and say, as a matter of law, these cannot be considered defamatory. The case can be thrown out on this basis. They also make the argument that for anything published in a book, that Meghan Markle does not have liability for those statements. She didn't write the book or control it, whether the statements are defamatory or not. So that's obviously on a technical matter of law. So let's look at what the alleged statements are, and are they defamatory? This is a federal case, remember. It's very serious. It's alleged in the book that Meghan had crossed paths with her half-sister only twice since growing up. Whether it's true or not, defamatory? A trusted confidant shared if there were more photographs of plaintiff and Meghan together, plaintiff would have sold them. Plaintiff reached out to the Sun and was paid handsomely for it. Allegation she was being paid for her stories. A confidant explained Meg didn't grow up with plaintiff. She barely saw her. The plaintiff alleges they had a much closer relationship. With an almost 20-year difference between them, the half-sisters simply never have been close. Defamatory, even if it's false? As one confidant pointed out, plaintiff did not care when she hadn't been invited to Meghan's first wedding. More than once, Meghan asked her father to intervene with the plaintiff. Then, allegedly at this Oprah interview, which I did not watch, the plaintiff says, Meghan said these horrifying statements. I grew up as an only child. Defendant only met plaintiff a handful of times. And that the plaintiff had only changed her surname to Markle after the Duchess started dating Prince Harry. And then this becomes underlined so that Miss Markle could cash in on her newfound fame. And the defendant makes the point that that part, the underlined part, is not in the transcript of the interview that was submitted with the original complaint, that was added into the amended complaint. So the plaintiff says, in the sum total of all these statements have cost her a great deal of anguish, damage to her reputation. She's been stalked and harassed by rabid fans of Meghan Markle. Her business has suffered. Book sales, I didn't know she had a book, so that didn't cost her a sale here. And I have a lot of books, but I guess there was somebody who was going to buy it who didn't because of what Meghan Markle said. That these things are all part of her damages, reputation, economic, etc. So in the arguments against this, of course, the defendant, Meghan Markle, her attorneys are saying that, look, these things for the large part are just opinions of Meghan Markle, whether they were close, whether they got to see each other a lot, whether she grew up as an only child, which in her view she did because of the age difference and the distance between them. that when you're just talking about your opinion about how a relationship was, you can't make that a case for defamation. That's pretty persuasive. Now, some of the statements about how if she'd had any more pictures, she would have sold them. She sold her story to the Sun for a lot of money. Yeah, those do kind of suggest a mercenary context there for the half-sister. But is it defamation that you sell things for money? That's a story. People sell stories all the time. If you write a book about yourself, you are getting paid for selling a story. So is that really so bad? I don't know. We'll have to see what the judge thinks about that. Maybe the worst, if there is one, for Meghan Markle is when she actually said in the interview with Oprah, which was that the plaintiff had only changed her name back to Markle after the Prince Harry had gotten involved. And then she goes, I think that's enough said about that. Well, factually, that is true. That is enough said about that. If they'd never said anything about it, that would have been enough said about it. Maybe if you had an implication, defamation by implication, you could connect that true statement of this is enough said about this to the other statement and go, you're implying that she did it just for money. Here, though, they are having to say that that's flat out, straight out defamation. I don't know about that. Just generally, should this case be in court, everybody's got their own opinion. The plaintiff obviously has the opinion that it should be. Now, the more technical issue is whether Meghan Markle can be liable for the statements of the book publisher. You remember back in the Depp case, Depp was found liable for the statements of his attorney based on the judge's jury instructions that that attorney was acting inside the scope of the attorney's agency. That's going to be the subject of Depp's appeal, I'm sure. It's pretty complicated legally, more than you would think off the top. This one is also a little strange because for certain, this is an unauthorized biography. These people were not hired by Meghan Markle and Prince Harry to write about them. This is an independent book. It really is. Even though Meghan Markle eventually contributed some information to it, the book writers wrote what they wanted to write. They weren't under her control. That's just the facts. So when someone out there just says something on their own accord, are you liable for that? Of course not. Even if you hire somebody to do something and they make their own defamatory statement, you're not liable for that typically because they're an independent contractor. These weren't agents of Meghan Markle, these book writers. So really it comes down to, did Meghan Markle say these things to the book writers to cause them to go out and then republish them in a defamatory way? There is a line of legal reasoning that exists in many jurisdictions that if you tell a third party something that's defamatory, not just to say it to them, but because you have the plan and the knowledge and you can foresee that they're going to go out and broadcast it to other people, you can then have direct liability for doing that. It's not so much vicarious. This is your own action that put this defamatory statement out into the public. Weirdly, though, Florida has not really adopted that, and especially the federal courts in Florida are extremely skeptical of that. And I think that Markle's attorneys have the better line of law here. It was kind of surprising to me because a lot of states see it differently. So when a case is in federal court on a state law issue, the federal court will look to the state court law to decide it. But there's not really a clear line of law on this in Florida. In fact, some of the most developed law is the federal court opinions guessing what the state would do if they were confronted with this issue. And that's kind of the best they can do if the state hasn't directly confronted it. You'd think after 200 years, we'd have all the questions answered by now and you could look up the answer, but that's not true. In a lot of states, there still remain many undeveloped angles of law, including in Virginia. In the Depp case, was the judge right saying that to the jury that this attorney could be found an agent for what he said and Depp liable for it? That's a different topic. It's not clearly settled. Here, this isn't clearly settled, but there have been similar cases decided by the federal court that says we don't care really the reasons for it. If a third party said something defamatory and you don't like it, sue that third party. You can't go behind the scenes and trace down a source and then sue that source for it. So I think the case here that the plaintiff has to hold Markle liable for what the book people said, it's pretty weak as the federal court has interpreted state law and likely to lead to dismissal of all of those statements. And that only leaves the three things that she said in the Oprah interview as a potential cause of action. The worst one of those, if there is a worst one, being about how she changed her last name, and that's enough said about that. So this whole federal case, in my opinion, will hinge on whether the judge reading it thinks, if you say, someone changed their name back to my famous last name after I got involved with this guy, and that's all we need to say about that, is that enough to sustain a defamation action in federal court? Probably not, but I don't know. We'll just have to see. Thanks.